Good morning. This is Susan Combs with Holland & Hart. Welcome to our first annual Wyoming Tax Conference, hosted virtually. Thank you to those of you who have joined us today. I'll start off this morning with a brief introduction about Holland & Hart. Holland & Hart has approximately 470 attorneys in 8 states and Washington, D.C. Our tax group has over 50 attorneys and specialists. We serve individuals, businesses, nonprofits, and family offices with a full suite of services on challenges that can affect one's financial health. Our practice areas include federal income tax, state and local tax, tax controversy, employee benefits, and private clients. In Wyoming, Holland & Hart has offices in both Cheyenne and Jackson with a combined 35 attorneys and specialists. In 2021, we are proudly celebrating our 30th year in Wyoming. For today's conference, our team selected a broad range of topics on federal, state, and local tax issues we believed most important for those of you with Wyoming presence and Wyoming operations. I'll provide some tips here at the beginning so that you can get the best experience possible from the WebEx platform that we are using today. So we've muted all participants in order to maintain the quality of our audio and visual connection. But if you do have a question for a speaker, there is a Q&A function at the right-hand bottom side of your WebEx screen. Next to the chat bubble, you'll see 3 dots. If you click on that, you'll see a Q&A box pop up. We encourage you to write questions in that spot. Speakers will do the best to answer your questions during the time available. But if you have more specific inquiries that we can't get to, we encourage you to follow up directly with the speaker. And the contact information is on our Holland & Hart website. Also, to get the most out of your WebEx experience, if you go to Layout, which will be in the upper right-hand corner of your screen, and you select that, you can select the option of Show Active Speaker with Shared Content, and that will allow you to see both the slides that the speaker is talking about as well as the speaker. A copy of the slides will be provided to you by email after the conference. And Luke, could you move to the next slide, please? CLE and CPE credits are available for today's presentation. The instructions are on this slide, which again will be provided to you. For those seeking CPE credits, please do the following. Respond to all of the polling questions that will be done during today's presentation. Complete the evaluation form that will be emailed to you after the meeting. And once the evaluation form is received, your CPE certificate will be provided. We'll start today with 2 presentations and a short break at 9:55 a.m. Our first panel includes Robert Jensen and Matt Michaeli. They will provide an update to you about the Wyoming legislature. Robert provides our Cheyenne and Wyoming clients with government affairs services. He served as COO and CEO of the Wyoming Business Council from 2004 to 2014. Matt Michaeli is a partner in our Cheyenne office. Matt has extensive experience with issues regarding mineral development on public lands. He helps clients with federal and state regulatory agencies on environmental issues such as permits, the regulatory process, and litigation. As you'll soon learn, Robert and Matt are very involved with the Wyoming legislative process. Before they get started, I will also introduce our second speakers, who will start immediately after Robert and Matt. And they are Adam Cohen and Sarah Harradon, who are both partners in our Denver office. They will be speaking on carbon sequestration credits. Adam and Sarah are both leaders in fund formation, corporate, merger and acquisitions, master limited partnerships, and real estate deal teams. They work closely with other lawyers in the firm to achieve our clients' transactional goals. And with that, I will turn it over to Robert and Matt to kick us off. Thank you so much.
Well, great. Thank you, Sue, for the introduction, and thanks to all of you who are participated in the webinar today. It's a real privilege to be in front of you. Matt and I are going to be talking about fundamental changes in Wyoming's tax revenues. And for those of you in Wyoming, have been here for a while, you know that we have been talking about this topic in Wyoming for decades. And it's a common theme that we have an unbalanced tax structure and an unbalanced spending structure. And so today, what we're going to really try to focus on in a few minutes is what hasn't changed in our revenue stream and spending activities in terms of government, what has changed, and what are the future impacts of those changes going forward, and what are possible structural solutions. So Matt, I think you're going to kick it off.
And again, thanks. It's good to be here. I think the first point I wanted to make is those of us on this call and those of us that are active kind of take for granted that people understand Wyoming's budget situation. And that's just not true. I think in Wyoming, we always have the problem of communicating with our citizens. It's such a big state, spread out, so many different media markets that people don't really understand. For just an example, last summer, a poll that I was a part of, Wyoming was facing a $1.5 billion deficit, just a huge fiscal crisis. We asked registered voters who are going to vote in the upcoming election. 62% said they thought Wyoming's budget was in good or fair shape, and only 38% thought that it was in poor or bad, which just is completely upside down of where those numbers should have been. So the point is, people just don't know, and we need to talk about this because we have real and systemic problems that are going to be hard to address that we need to start looking at. So as we look at that, the slide that we have up is kind of the basic problem. And this is from the Wyoming Taxpayers Association. There's a whole bunch of different groups that have done this, and they've all come to basically the same point. For every $1 that a citizen of the state of Wyoming pays in local and state taxes, they get $9 back. And so here you say, an average family, average home, couple kids receives $27,000 a year in services. That same family only pays $3,500 a year in taxes. So that gap is made up for by the mineral industry. So the mineral industry is taxed a bunch of different ways: severance tax, ad valorem tax, property taxes, sales taxes that are all paid by the mineral industry have covered that gap for us really since statehood, but certainly as our budget has grown. We'll talk more about this going forward, but it shouldn't be a surprise to anybody on this call that the mineral industry has struggled, that it's not what it was 10 years ago or 20 years ago, and that's especially true with coal. And while we absolutely want to do everything we can to support the mineral industry, we also have to look at this with eyes wide open, that revenue from the mineral industry cannot be expected to be at the levels that it has been.
Yeah, so here's another slide talking about what hasn't changed, and this may be a little hard to read, but the point of this slide is basically, you see it, Wyoming's personal tax burden is the lowest in the nation. And so you see these little circles down here. It's an example of several different kinds of taxes. So in property taxes, the personal property tax paid by Wyoming residents, me, Matt, some of you, is 49th in the nation and the lowest of all of our neighboring states. For sales tax burden on a personal basis, we're 43rd in the nation of states that actually have a sales tax. Of course, Montana doesn't have a sales tax. Several states don't have one. The total tax burden as a percent of income for a person in Wyoming is the 48th in the nation, and the total tax burden for a household that earns $50,000 a year is we're 50th. We are the lowest taxed populace of any state in the nation. And this goes to what Matt was just talking about before, the imbalance between the services that are provided by state government and who pays for the cost of those services going forward.
And, you know, I think that's a huge part of why we all live here and why we love Wyoming is we love our low taxes and we want to keep it that way. The flip side of that, though, is that Wyoming, while we pay no taxes, the state actually collects an awful lot of revenue. And you know, depending on what studies you look at or how you measure it, we are always at the top of revenue collected per individual. And that's, again, because we're not a low tax state. We just tax a very narrow slice of the economy very heavily. And so here we talk about, again, what hasn't changed. And we've been blessed and we you know, been able to rely on the mineral industry for so long. But this is a chart that shows our education spending per student, you know, over the last several decades. And it's pretty stark. And one of the real, as we talk about the structural deficit, one of the problems we have is, you know, there's lots of things that go into this, a series of lawsuits, a series of different things that have happened, but our education spending is pretty much on an autopilot that it's going to increase year over year. And, you know, we spend far more on education on a per student basis than the regional average. We spend far more than similarly situated states. And as we look at what has to be done, at the top of the list has to be our education spending. That we simply, if mineral revenue continues to go down, we simply cannot afford the money we're spending on education without some sort of fundamental change to our tax structure, which you know, probably doesn't have the support. So the first thing that we have to look at is this education spending and how much we are spending on a per student basis.
Yeah. So now we're starting to go down the story of what has changed. And as we've said previously, we're in a fundamental shift in where our revenues come from. Now, we've been here before. We've had significant ups and downs in our revenue stream, mostly driven by the mineral industry because that's what drives our revenue streams primarily. But what's different now is it is highly unlikely that this mineral revenue stream is going to come back and save us from these structural deficits that we have. And this slide essentially points that out. So when you look at what the revenue from minerals was for the state of Wyoming in 2013, it was overall revenues for 2013 and 14 was $6.4 billion. In 2017 and 2018, the revenue was down to $5.2 billion. That's a $1.2 billion reduction, and $1.1 billion of that reduction was driven by the mineral industry. So you can see that going forward, and it's worse than that now. These slides are from 2018, and thank you to the LSO staff for this information that was put together for a revenue committee meeting a while back. But these numbers are telling, and if they were updated for today's numbers in these charts, it would be even worse. And so what we're seeing is a fundamental change in our revenue stream that is not likely to bounce back and provide any relief for the funding of government services. And so we'll talk in a minute about what that looks like in terms of what's had to happen with our budgets. But this is the main problem. We have an unbalanced tax structure that is far too dependent upon mineral tax revenue, and people in the state of Wyoming are going to have to realize that they are going to have to come to terms with how do we fund government that has mostly been paid for by minerals. Who's going to who's going to fill that gap?
And if you think about it, just quick, the three stools of the minerals is coal, oil, and natural gas. And coal has kind of been the base load, the stable one that's been there, that's provided this huge, and oil and gas kind of bounces around up and down. But everybody understands coal, the production of coal, you know, we've gone from almost 500 million tons a year to, you know, under 300 million tons a year. And that number continues to decline. We all know the majority of our even oil and gas development comes from federal minerals. The future of that, and I believe in it, and I'm going to fight for it every day I can. But again, we have to understand it's getting more and more difficult to rely and to just assume that those revenues will be there going forward. So this slide shows what we've done with the general fund budget, what our legislators done with the general fund budget. And I just want you to compare this to the slide we had a few minutes ago with the education fund, where it had increased rapidly. The legislature has actually done a pretty aggressive job of cutting general fund dollars. You can see it's gone from a $4.2 billion budget in 2010 to a $2.5 billion budget today. So it was just passed in this last session. So you think of that, that's not inflation adjusted, that's actual dollars cut from the budget. And so our state government is operating on about almost 40% less today than it was 10 years ago. You talk about households, you talk about any government, show me any budget in the world that is operating on 40% less today than it was 10 years ago. The point is here that we've really been aggressive. We've really made a lot of cuts in the general fund. I'm not saying there's not more places to cut, but you know, this idea that there's fluff or there's fat, or, you know, we can just solve this by you know, rooting out the fraud is really not true. I mean, the cuts that are left are going to be painful, and that's the real point of all this. And cutting education obviously is hugely painful. But we are faced with some very difficult decisions. The easy decisions have already been made, and we need to figure this out.
Okay, so now the fun begins. We have polling question number 1, quiz time. So those of you that are doing continuing education, here's a question. Now, I know it's a tough one, but you know, if you need some help, we're here to help you. But what has changed in Wyoming's tax structure over the recent years? And here's on the side is your place where you answer that question. Wyoming tax revenues, and the cost of government imbalance, K-12 spending, student funding, mineral revenue from 2013 to 2018. Wyoming's personal tax burden is the lowest in the nation, or E, all the above. So while you're contemplating that question, we'll continue to move on and hope we don't distract your concentration. So that's sort of what has changed and what hasn't changed. Now we're going to talk a little bit about the future implications of what has to happen going forward. So as Matt just said, we probably will have to have further cuts to our general fund budget. That will be very painful. The ones that we have taken so far, particularly in this last year, have been very painful. They've hurt a lot of people. And so, you know, that's just the truth of the matter. And we are going to have to continue to take serious looks at our general fund budget and see where we can gain efficiencies, what more could be cut. And in some cases, there'll probably be some putback, but we clearly are not going to go back to the $4.2 billion budgets of the past that are driven by mineral revenue. Another thing that we'll have to take a serious look at are K-12 budget cuts. I just don't see how we can move forward with the kinds of structural deficits that we have in the K-12 education spending budget without taking some sort of significant cut. The general fund budget over the last 10 years has been cut 40%. The K-12 budget hasn't really been cut at all. And so, you know, we've reduced increases, but significant cuts have not been made in the K-12 budget. And we're going to have to take a serious look at that. We're going to have to, I think, look at some structural changes in K-12 education. I know that the superintendent is looking at that. I also know that the governor has been looking at that, and certainly the legislature has been working on that for a long time. We just had the session that just ended, had an opportunity to do some significant work on that budget, and the House and the Senate could not agree on that. So those are leadership issues that need to be addressed. But the fact of the matter is that we're going to be out of money in about 4 years if we don't have some kind of change in our K-12 budget. And in addition to that, I hate to say it, but I think that we're going to have to look seriously at new taxes, new revenue streams, and we really have to look at ways that we can look at our tax structure from a standpoint of the broadest base possible. We'll be talking about that a little bit more, but this notion of only taxing, generating new revenues from taxes only on businesses is a non-starter. It just is, it's the easy way out, and it doesn't really solve the problem. The folks that have been receiving the services have to start paying more for those services. Now, if we don't want those services, that's fine. We should cut them out. But the fact of the matter is that we as residents here, we as citizens, have not paid our fair share as individuals for the government services that we're receiving. And so the broad-based tax has to be the first answer going forward. And that's always the hardest one, because those people vote and businesses don't vote. And so it's easier to pass a tax on a business, on manufacturing, or on the wind industry, or any vulnerable business that could help diversify our economy and our tax base. Should be the last place where we raise taxes. We as individuals have to do that. So I'm done preaching. Go to the next slide.
And so we're getting up against our time here, but just to kind of try to bring this all together. The first point is, we as Wyoming citizens need to be informed. We need to understand this. There is a cliff coming. It is rushing at us, 100 miles an hour. We've been able to kind of avoid it by using rainy day funds. By this time, we had a bunch of money come in from the COVID funds for the federal government, and so we keep ignoring the cliff, but it is there, and it is coming. I think the biggest thing for me is that my biggest frustration is that it's time for us. It's time to just have real leadership. Bob talked about none of these decisions are going to be easy, but when we interact with our legislators, when we interact with our policymakers, we need to have honest and blunt discussions with them. We see these legislators that sign a no new tax pledge, but then at the same time promise to not make any cuts to education at all. And those two things are just,
they're incompatible.
You can't do that. You can't have it both ways. And so we can't keep pretending that we can be one of the highest spending states and spend more per capita than any state in the country, and the lowest tax state in the country. We've got to figure out who we are and what we want, what services we need, what services we can do without, and then where we can make cuts. And I think until we address education spending, we're never going to make this, we're never going to bridge this gap, and we will end up going over the cliff.
Yeah, and I just want to reiterate a couple of quick points. This bullet point of disciplined, realistic, and intentional leadership is necessary. That starts with us as people that live here in the state of Wyoming. Individuals need to stand up and be able to have these conversations with their legislators and with elected officials about how we pay for the services we consume. We have to stand up and be willing to have those conversations and be disciplined enough to understand that we have to pay a little bit more to do that. And then the second point is, this guy on the wagon, that's Matt. So here's the second polling question. for the folks that are doing continuing education. Which of the following are future implications of the Wyoming's tax structure? Further general fund budget cuts, K-12 budget cuts, new tax increases, all the above. I could give you the answer, but I think I think you understand it. So I think we're done. If you have questions, you can do the Q&A on the side, and we appreciate your time and interest. And you can always contact us at Holland and Hart if you want to talk about this further, and we appreciate your time.
Great. Well, this is Adam Cohen. I'm going to be presenting with you for you with Sarah Harridan. I'll let the folks behind the scenes switch over so that she has control of the slides, and we'll get started here momentarily once we advance to advance those slides.
Yeah, I still don't have control yet.
Sarah, you should, if you want to, there's a capsule on the left, and you should be able to, if you hover over the slideshow with your mouse cursor, you should see kind of a capsule, and you should be able to advance slides that way.
Isn't it just page down as well? Oh, there we go. Now I did. That worked. Okay, great. Thank you.
Great. So Sue did introduce us at the top of the hour, but just a quick recap. Sarah and I are partners in our tax group. We both practice in the federal tax area and focus a lot of our attention on tax credits. We want to talk to you about one in particular because it's sort of a new and emerging area. The credit's been around a while, but there's new regulations on them. The credit was enhanced recently and is a topic of new legislation pending. So we're gonna jump right in and first get a handle on what your guys' experience is in this area. I think we'll probably gear a little bit towards the folks that can answer B, but please answer honestly, if you would. So Sarah, why don't we go on to the next slide and we'll get started. So as I mentioned, this is a credit that has actually been around for a while. However, it was fairly slim. It was $20 per ton of carbon oxide that was captured and disposed, or $10 if used in enhanced oil recovery, EOR, or utilized. Utilized meaning that the carbon oxide is put into another product. Could be put into concrete, it could be put into plastic, but it's utilized, so it's kept out of the environment by being put into other projects. That older credit, not only was it slim, but it was subject to a national cap. So once enough carbon oxide had been captured, the credit just stopped. And so a lot of people had a hard time investing in this credit because they didn't know when or if their credit would be eliminated halfway down their credit period. In 2018, the credit was made much more viable. In particular, it was increased. So you have now $50 per ton if it's disposed, or $35 for EOR or utilization. And most importantly, to my mind, is that there's no cap. So as long as you put the effort into getting a project together, you will know that for 12 years, you will get the credit. That 12-year period lasts from placement in service. And so that's the critical distinction between the two credits. Sarah, if you'd go to the next one. So some people say, well, okay, but maybe I already have some a project, maybe I already have a facility out there and I'm doing some of this EOR. How can I take advantage of the better credit? Well, there's three ways, besides just building a brand new project now, to get that better credit. One is that they gave us an election. So as long as the project will capture at least 500,000 tons, then you can make an election. Now, that election treats you as placed in service back in February of 2018. So at this point, every day is a part of the credit period. The 12 years is ticking. So if you're going to use that grandfather election, you better give Sarah a call right after this. The other way to do it is by using what's called the 80-20 test. The 80-20 test looks at whether the equipment that you put in service, whether 80% is from new equipment and 20% or less is from used equipment. So this one, if you've got a compressor and you need a dehydrator, for example, and you need to replace that compressor, well, that may be enough, even though you keep the dehydrator, to trigger this 80-20 test. As a nice benefit in the regulations, they also said that while transportation is not part of capture, disposal, utilization, or enhanced oil recovery, transportation, if it is newly built, that can be part of the 80-20 test. So you can use a pipeline that you have to construct to get to wherever you're going to dispose, utilize, or EOR the carbon. You can utilize those costs as part of your 80-20 test. And of course, there's also the ability to add additional equipment. So you may have one line of carbon sequestration equipment. Well, you can add a second process train. And that second process train, because it will add to the capacity to sequester, you'll get the new credit on the new equipment, even though you have some old equipment. So there's these different ways that you can actually potentially have a particular project that's already existing, take advantage of the new credit. And of course, the one that's not on here is just building something brand new. Okay, Sarah.
Okay. So as Adam kind of mentioned at the beginning, the credit, the tax credit is available to the taxpayer that captures the carbon and also either disposes or utilizes the carbon using carbon capture equipment that is placed in service at a qualified facility. So the definition of a qualified facility here becomes quite important to make sure that the carbon that you're attempting to capture is coming out of a source that is permissible under the statute. So a qualified facility has generally two requirements. One, the construction of the facility must begin before January 1st, 2026. In the original statute, that date was January 1st, 2024, but it was extended in 2020. So that's the first requirement, and we'll talk about that. And the second is generally that the qualified facility itself must meet certain capture requirements. It must capture a certain amount of carbon. So first, let's talk about construction begins before 2026. So that means for the qualified facility itself, construction has to begin. So you could use you could build a new facility or use an existing facility. But as part of that requirement, the construction of the carbon capture equipment also must begin before 2026, or the original planning and design for the qualified facility had to include the installation of the carbon capture equipment. So it's really a way, I guess, generally what that means is the beginning of construction requirement is also with respect to the carbon capture equipment. So what does that mean? For those that are familiar with energy tax credits, beginning of construction is a very familiar term of art. The IRS published a notice 2020-12, that piggybacks off of the guidance for wind or production tax credits and investment tax credits for solar and wind projects. That construction can begin either in one of two ways. One, you start physical work of a significant nature, or 2, you spend 5% of the total project costs. For a qualified facility, for those, once you begin construction, you have to either make continuous construction efforts towards completion, or you have to make continuous efforts towards completion. But it's referred to in the tax credit world as the continuity requirement. You'll be deemed to meet continuity if you place the qualified facility and the carbon capture equipment and place it in service within 6 years of beginning construction. So that's an important date. So that's construction begins. The other requirement is that the facility generally must be either what's called an industrial facility or a direct air capture facility. And that's industrial facility it's an electric, we have the definition up here, but an electrical generating facility that produces carbon dioxide from a fuel combustion source, fuel cell, manufacturing process, fugitive carbon oxide emission source, and that absent capture, disposal, injection, or utilization would otherwise be released into the atmosphere. So that's, you think about your gas processing plants, your ethanol plants, that covers a wide variety of facilities. The last part of that requirement is that the facility itself, if it emits less than 500,000 tons of capture of 500,000 tons of carbon, it must capture at least 25,000 tons of carbon. For all other electrical generating facilities, the facility must capture at least 500,000 tons. And then for all other facilities, which would include a direct air capture facility, it must capture at least 100,000 tons. So as we said, the credit is available to the taxpayer that owns the carbon capture equipment, except Adam's going to talk about an exception to that. But generally, it's available to the owner of carbon capture equipment that is placed in service at a qualified facility. So what is carbon capture equipment? The definition in the statute and in the regulations is quite broad. You'll see here it's all components of property that are used to capture, process, for just, until it's transported. So as Adam was saying, it doesn't include the transportation equipment. It wouldn't include the pipeline. But it's used for the purpose of separating, purifying, drying, or capturing, removing, compressing. So this definition has become quite important in projects because it can include equipment that's already part of an existing industrial facility. For example, in a gas processing plant, equipment that's used to separate, different elements or different from a gas stream would, folks would think of that as equipment that's part of the gas processing plant that could also be under this definition part of carbon capture equipment. And so there's a question, I think, surrounding, there's still I believe there's an outstanding question, I think Adam does too, as to whether or not the taxpayer that's claiming the credit has to own all of the carbon capture equipment at a qualified facility. And I think the IRS is hopefully going to come out with some guidance to say, no, you can actually, two different taxpayers can own carbon capture equipment, but it's the taxpayer that is going to, capture and then dispose, inject, or utilize the carbon that is eligible for the credit. So hoping that we're going to have some guidance on that piece of it, because right now it is, for the existing equipment that at an industrial facility, it doesn't always make sense for the taxpayer that wants to invest in these projects to also own that equipment. All right, with that, Adam, I think I'm gonna.
Great. And I was looking at the poll while Sarah was talking, and we have quite a few people who have no familiarity. So I'm going to back up just a little bit and just make sure that everyone is tracking. Both Sarah and I have referred to carbon dioxide, and there's this term qualified carbon dioxide. Carbon dioxide is what you remember it from chemistry class. It's carbon monoxide or carbon dioxide. Either one can be a qualified carbon dioxide. The qualification is that it has to be produced and captured here in the United States. So you can't capture it and then send it up to Canada or down to Mexico. and if you meet those requirements, then you have that. The other dot that I wanted to connect for you was to put together the earlier slides where we talked about it's $50 per ton to capture, and a minimum really of basically 100,000 tons in most cases for the minimum capture each year. So it's a pretty rich credit, in fact, if you think about that, because that's $5 million a year coming from the federal government. That can support quite a lot of cost up front, right? Because that's 12 years. So potentially $60 million for each project. So anyone out there with a facility that is producing either carbon dioxide or carbon dioxide should really be looking at this project and this credit. The other point on the last slide that Sarah made at the very end was that the people who own the facility don't have to be the ones that own the carbon capture, which gets into this very slide. This is one of the most flexible credits that the federal government, at least, provides. And that's because of that first rule, right? So you don't have to own the whole, coal electric plant. You just have to be the one that captures the exhaust, separates out the carbon dioxide, and puts it somewhere. And there is this attribution rule, and this attribution rule says, well, if you are the one that and under the new credit, if you're the one that owns the carbon capture equipment, then it's attributable to you. And as the bottom of the slide indicates, you can pass it on to the person who captures for you. So there are really potentially three different parties involved here. There's the party that owns the industrial facility, the party that owns the carbon capture equipment, and the party that does the work of disposing, injecting, or utilization. And either of those last two parties can own that, can claim the credit, because while it's attributable to the one who owns the carbon capture equipment, it can be passed, which gives a lot of flexibility to parties to negotiate an economic deal among themselves. There is some difficulty because of the issues that Sarah mentioned about what is carbon capture equipment in terms of this requirement that the person have to own the carbon capture equipment to have the credit attributable to them. If you've got a plant and you've got your smokestack sending out a gas that includes a carbon dioxide, at what point is the capture occurring can be critical, because that is the point from which the person who's going to claim the credit or pass it along has to own the equipment. And that can be very difficult if that capture is perhaps part of the permit that is required for the facility to operate. So that's an issue that is definitely a hot issue in Washington, and we're hoping to get some sort of guidance that will allow us to make a little bit of a differentiation on where that point of ownership has to start. Because they do have a rule that says only one taxpayer per process train can have the credit attributable to them. On the party to whom you can pass it, you can't pass it and pass it and pass it. So you can't go to the subcontractors of the party that captures disposes. You can't go to the individual employees, that sort of thing. There's also a requirement that that person have the permit for the disposal, injection, or utilization. So that does put some level of liability and responsibility on that person beyond just contracting to do it and then passing that contract obligation on. Sarah, you want to take it from there?
Yeah. So recapture. So recapture is a term used in the tax credit world. So you'd use generally in the tax world, just to imply generally that if you take a credit and then you're no longer eligible for that credit within a certain period of time, you have to pay the credit back to the Treasury. So recapture in the carbon sequestration world is generally based on a 3-year term, but what it means is if you claim credits for carbon that you have sequestered and then the carbon later leaks into the atmosphere, you essentially need to pay back some of the tax credits that you took with respect to that, with respect to that sequestered carbon. It's done on a net basis such that you take into the amount of carbon that you captured that year, minus, the amount that's leaked into the atmosphere, so that you pay, based on the net basis for each year. The recapture, it's also done on a LIFO basis, meaning that you would start with, with the first, the current year, so the net basis, let's say you're over, you've leaked more than you've sequestered that year, you will go back to the previous year that you took, the most recent year that you took credit. So a last in, LIFO means last in, first out, for those folks that don't practice in this area. The recapture period with respect to the credits is generally, it starts on the date of injection, and it ends at the earlier of the 3 years after the taxable period for which the credit was claimed, or the date with the relevant monitoring requirements end. And those monitoring requirements, excuse me, under the EPA or under ISO. So it's the earlier of those 2 periods. Prior to the final regs, that period was 5 years, if I remember correctly. But so I think taxpayers think the 3-year period is reasonable, kind of, a win. 5 years was a long time, I think, for folks to have this potential liability outstanding. Am I going to have to recapture this credit if for some reason there is a leak? If carbon is sequestered in based on multiple, different owners of carbon capture equipment, the regulations provide that it's allocated, the recapture is allocated pro rata based on the owners of the carbon capture equipment. There is no general, what we call safe harbor for recapture, but there are limited exceptions to recapture with respect to events, leaks that arise from actions that are, not related to what they call the selection, operation, or maintenance of the storage facility. So, for example, if a volcano or an earthquake happens, I guess, in some ways you could argue that you put the sequestration site right next to a fault line or something, but the regulations do provide that, generally speaking, recapture, that it results from actions that are outside of the control of the taxpayer, so to speak, are not, do not cause recapture.
And I just interject before you go on.
Yeah, please.
If you, in most cases, that monitoring is going to have to go on for much longer than 3 or 5 years. Depending on the state and the permit, it could be 50 years. So having security that once you take your credit, you wait 3 years and that credit cannot be recaptured anymore, even if there's a leak, 10, 15 years down the line. That also should help people get comfortable with this credit.
Yeah, no, that's a good point. So you could, you might have existing liability to the EPA, for example, for many more years than you would having to recapture the tax credits, which, as Adam explained, can be, $60 million potentially, right? So that's a favorable result, I think, from a taxpayer standpoint. So last, we wanted to talk a bit about some of the various congressional proposals that are on the table with respect to carbon capture, the carbon capture tax credits under Section 45Q. As part of Biden's infrastructure plan, he also sort of mentioned, and we'll talk about that in a second, but or has some extensions for carbon capture tax credits. And these are the 3 major proposals that are out there. There are some other smaller ones in the House and the Senate that have been proposed, but these are the ones that are getting the most traction, I think, and press. I will note, so the Senate Clean Energy for America Act, that does have a 5-year phase out when emissions targets are reached. So, you know, as Adam was talking about in the beginning with the pre-2018 credit, there was this uncertainty with, well, if I put all this money into a project, am I going to be eligible to take the credit, or is it going to be used up? And I read somewhere, I think it was pre-2018, there were 11 projects that were taking all of the credits. So it was really not, you know, it wasn't a lucrative or a good, you know, efficient idea for folks to be putting all this money into these projects. So there is that, you know, that potential, I think, with the Clean Energy for America Act. The other two acts also extend the beginning of construction date out a few more years with respect to the Senate Carbon Capture Amendments Act, and then 1 extra year for the House Green Act. And those are important dates because it gives folks a longer time to sort of, you know, to get this together, to get a project together, to, you know, to decide to make this investment, to begin construction. I think the most interesting piece of this is the direct pay options, which Biden's infrastructure plan also included a direct pay option for the carbon capture tax credit, as well as there's direct pay proposals on the table for the investment tax credit and the production tax credits. But what's interesting about these is, so direct pay is you don't have to have tax capacity to take the credit. So right now, a lot of these projects are, you know, especially in the solar and the wind space, and you know, carbon capture is looking to be the same. Is a developer, or, you know, in this case, an owner of an industrial facility, has the carbon that needs to be sequestered. They need money to build out the project. They also don't necessarily have the tax capacity for the tax credits, meaning, you know, maybe they're, you know, paying AMT, or maybe they're an overall loss taxpayer. So they usually have to go out and seek financing, and a lot of that financing some of that financing comes in the form of tax equity investors. And these are, you know, Fortune 500 companies, banks that have capacity, you know, usually corporate taxpayers, because there are restrictions with respect to tax credits for individual taxpayers that have the tax capacity to use the tax credits. And they, you know, seek financing from those folks as well. A lot of them are done through partnerships or lease structures. That's a whole different presentation. But long story short, direct pay means, you know, that the developer itself can actually treat the tax credits as an overpayment of taxes and apply for a refund, rather than potentially having to seek tax equity. There's a question regarding timing. So, you know, these credits don't start accruing or don't start generating until after the placement and service date. So there is this time period of, you know, between to build out, you're going to, you know, presumably to take advantage of a direct pay option, you're going to have to seek some sort of a bridge loan financing to get to, you know, to fund the expenses associated with a build out of a project, because these projects are not cheap. But there is this question of whether or not the direct pay option will, you know, eliminate the tax equity market. And you know, you'll see the House Green Act has reduced the direct pay option to 85%, so that folks that are applying for direct pay wouldn't get 100% of the credit value as a refund or as a cash payment. They would get 85%. But the other two, the Senate and Biden's proposal, have 100% direct pay. So there's a question about, you know, whether or not, you know, what that will do to the tax equity market. Adam, I don't know if you want to say anything. This is a real hot area. About...
it really is a difficult issue. There's policy arguments on really both sides. You know, the reason the direct pay at 85% in the House proposal is that you know, tax equity for them, for it to make sense for another taxpayer to participate, they need to get a benefit from the credits. And so typically the economics are structured to have the tax equity put in cash into the project at some percentage of the tax credits that they get. So if they get $1 of credit, maybe they put 85 cents, maybe it's 80 cents, maybe it's 90 cents. But they put in some portion of that credit. So they essentially are picking up as profit, so to speak, that differential. So that's where that lives. Um,
Mm.
direct pay at 100% means that you totally cut out the tax equity, which can serve a purpose from a compliance standpoint, because the tax equity is generally risk averse. This usually isn't their business, right? If it's a Fortune 500 company that's trying to get tax credits from another source like this. And so they serve a valuable tax compliance aspect of bringing in a skeptical eye that the IRS just doesn't have the resources to do to audit every single project. So it'll be interesting to see. Why don't we go on to
Yeah,
the
let me
last,
get, yep.
oh, yeah.
Let me do the, sorry, we do the last polling question real quick before we run out of time so folks can get their CLE and CP credit. So which of the following presents an opportunity for the generation of carbon capture sequestration tax credits? They're up there. I don't need to read them for you. But thanks so much for listening. And I'm going to let that, if that's okay, Sue, I'm going to let that sit there while we're out or on the break.
That's fine. Thank you, everybody. We are going to take a short break and resume promptly at 10:05. Thank you so much. 10:05, so we will get started with our next two presentations. First, you'll hear from Casey Benish and Walter Eggers. They are both attorneys in our Cheyenne office. Casey represents clients before the federal and state courts, as well as the Wyoming Board of Equalization. Walter advises and represents clients on state and local tax matters, as well as energy-related issues in the state and federal trial and appellate court levels, as well as before legislative committees and the Wyoming Board of Equalization. They will be talking about some hot topics in Wyoming state tax. After that, we'll move directly into a presentation about hot topics in federal tax controversy with myself and Bill Colgan. We are based in the Jackson, Wyoming office and help clients nationwide. Bill Colgan began his tax litigation career as a trial attorney in the tax division of the U.S. Department of Justice in Washington, D.C. In private practice for 25 years, his practice focuses on corporations, partnerships, individuals, and other clients in complex IRS exams and appeals. Bill also defends clients in federal, criminal, and civil tax investigations by the U.S. DOJ and U.S. Attorney's offices. He has appeared in hundreds of tax litigation cases in state courts, tax court, federal district and bankruptcy court, and courts of appeals, and speaks regularly throughout the country on tax controversy and litigation topics. As for myself, I also represent clients in complex federal IRS exams, appeals, tax controversy, risk management, and resolution of tax issues. I'm also a commercial litigator and have tried cases, presented hearings at all levels of court, and handled hundreds of depositions. So without further ado, I'd like to kick it off to Walter and Casey.
Thanks, Sue. And to start off, we'd just like to thank you all for being here. And just to let you know that we've built in some time in our presentation to do a quick question and answer session here at the end. So if you have any questions for us as we go along, definitely type them into the question and answer little panel on the side there so that we can get those answered hopefully by the end of the presentation. And to start us off, we're going to have you answer a polling question, and we would just like to know if you or your company have been involved in an appeal in front of the Board of Equalization or the Wyoming courts. And while you answer it, it's just a quick yes or no. Walter's going to discuss some quick introductory things with you.
Good morning, everybody, and thank you very much for joining the conference today. We're delighted to speak with you. As Casey said, I'm going to use this first slide to give just a brief introduction to the Wyoming state and local tax appeal process. There's a couple of different layers, a couple of different players, and so we wanted to go through and just give a brief introduction before we move into some hot topics, as Sue said. So there's really three types of state and local taxes that we address in our practice. The first is sales and use tax. The second is the traditional property tax. And then the third are the production taxes in Wyoming. Those are the severance and ad valorem taxes that Matt and Bob talked about at the beginning of the day, the production taxes on minerals that are produced in the state. And I just want to take a quick minute and talk a little bit about how appeals in each of those categories proceed. First of all, with respect to sales and use tax, those are handled mostly by the Wyoming Department of Revenue. So decisions are made by the department. And then if a taxpayer disagrees with those decisions, the appeal is made to the Wyoming State Board of Equalization here in Cheyenne. If either party, the department or the taxpayer, disagrees with the state board's decision, then they can appeal to the Wyoming courts, which means the district court and then eventually possibly the Wyoming Supreme Court. So that's sales and use tax. Then if we move to the traditional property tax, this can happen in two different ways. First, for the majority of our practice, we appeal property tax decisions to the County Board of Equalization. So the county assessor, the elected county assessor in each of Wyoming's counties, issues assessments on an annual basis, and the taxpayer has the right to appeal those assessments, and that goes to the County Board of Equalization, which is made up of the elected county commissioners. So that can be a very interesting panel and venue for a tax appeal. If the taxpayer or the assessor disagrees, then the appeal goes to the state board and eventually to the Wyoming courts. Briefly then to the production taxes, and there's two production taxes I'll mention here first. The first is the traditional severance tax paid to the state, and then there's a complementary ad valorem tax paid on mineral production, which goes to the county where the production took place. All of the minerals, however, are valued by the State Department of Revenue. So any appeal in the mineral tax area goes to the state board and then eventually to the courts, the district court and the Supreme Court. There's also another important state agency involved in these types of appeals, and that's the Wyoming Department of Audit. It's different and separate from the Department of Revenue, but as its name suggests, it conducts audits, mostly in the sales and use tax and mineral tax areas. And those audits can and frequently do generate appeals that typically go up to the State Board of Equalization. All of these appeals are governed by Wyoming's tax statutes, as well as by the Wyoming Administrative Procedure Act in the statutes. And also both the Department of Revenue and the State Board of Equalization have procedural rules that govern these tax appeals. So that's just a quick overview of the tax appeal process at the state level here in Wyoming. What we wanted to use the remainder of our time for is just to hit on some hot topics. And this is not intended to be everything that's going on in the state at this point, but instead just to give you a flavor and a sense of the types of issues that we are dealing with and that other lawyers in the states are dealing with in the tax appeal process. So I'll hand it back over to Casey.
Going to do another polling question here really quick, and we just want to know what categories of state and local tax your work might involve. So whether that's mineral production taxes, sales and use taxes, property taxes, or other Wyoming fees and taxes, or if your work doesn't involve Wyoming state and local tax, that's of course an answer as well. So I'm just going to move on while you kind of answer that question. And our first topic is excise tax and taxable events. And in this case, we have a towing company who appealed the Department of Revenue's decision that changing tires, jump-starting vehicles, and performing lockout services were subject to excise tax. And when you have an appeal such as this on whether or not something is a taxable event, the taxpayer only has to bring forward enough evidence so that the fact finder can decide the case. And the department actually has the burden of persuasion, which means that they have to convince the board why their opinion is correct and why this should be a taxable event. And under Wyoming statutes, companies actually have to levy an excise tax on any sales price that is involved with repairing, improving, or altering tangible personal property. And the parties in this case actually agreed that vehicles were tangible personal property. And in 2019, the department actually issued some guidance that jump starts and changing tires were repairs. And then in 2017, they issued guidance yet again that jump starting vehicles, performing lockout services, and changing tires were taxable events, but did not disclose whether they were improvements, repairs, or alterations. And the board will actually defer to the department's opinions on rules and regulations unless they are clearly erroneous based on the language of the statute. And what's really interesting in this case is despite their 2009 opinion, the department actually conceded that unlocking vehicles, changing flat tires, and jump starting vehicles were not repairs, but were instead alterations or improvements to the vehicle. And improvements and alterations are not statutorily defined, so the board actually goes to the dictionary definition. In this case, the owner of the towing company came in and testified that jump-starting vehicles, unlocking them, and changing flat tires were not alterations or improvements. An auditor testified, of course, that she disagreed and that they were improvements or alterations. For example, she had stated that when you perform an unlocking service, it alters the vehicle from a locked state to an unlocked state. the board had found that the department stretched these words beyond their true meaning, and that there was no support for the department's interpretation within the statutes. And so the takeaway from this case is really just to follow those taxation statutes. And if anything's not defined within them, you can always look to the dictionary to try and place that into context, because that's exactly what the board's going to have to do. And that the department's published opinions, of course, are always a useful tool, but that doesn't mean that they're correct based on the language of the statutes.
And thank you, Casey. Casey mentioned the published opinions, and what we've done in our slides here is we've included links to some recent, what we consider to be important decisions, mostly of the State Board of Equalization. And so I think you're going to have access to these links after the presentation. You may want to take a look at some of these cases. Now I want to move to what I call the traditional property tax and give a quick overview of one of the topics that we're seeing in this area. And again, I mentioned that most of our work has to do with appeals that are made from the county assessor's decisions. There's also appeals that can be made from Department of Revenue decisions in property tax matters, but that's limited to certain categories of taxpayers: utilities, electric generators, generation companies, telecommunications companies. Those property tax decisions are made by the department and appealed to the State Board. But what we focus on typically are appeals of county assessor decisions to the county board. And one of the issues that's come up recently in a couple of different counties is the valuation of complex industrial property. So assessors in Wyoming, and this is true in other jurisdictions as well, really have three valuation methods that they can use to value property for property tax purposes. They can use the cost method, the market approach, or the income approach to valuation. And what we and others have seen across the state is that assessors and their experts will typically use the cost approach. And they do this, we think, because on an annual basis, it is easier and more straightforward for them to simply update the value based on changes that are made to the property, based on depreciation, based on obsolescence, and just sort of keep a running spreadsheet of the property associated with complex facilities. There have been challenges recently to the assessor's use exclusively of the cost approach, where taxpayers have argued that the assessors should and must at least consider, if not employ, the market approach and the income approach to determine the correct fair market value for tax purposes. So there's been several appeals to county boards and then several appeals up to the State Board, where that issue, whether the assessors are required to use income and market, is part of Wyoming law. And taxpayers have been somewhat successful in this regard in requiring the assessors to consider those other points. There have been a couple of cases, one involving a major oil refinery in the state, another involving a large natural gas storage company, where there have been successful challenges to assessors' decisions to only apply the cost approach. So again, just a quick sense of the kinds of issues that we are dealing with in the property tax area. Now we'll try to move on.
So the next topic that I'm going to discuss with you guys here today is mineral production taxes, the imposition of tax on waste mine gas. And in this case, we have an operator of a trona mine, and they actually process trona into soda ash using dryers fueled by natural gas. So waste mine gas is actually an inevitable consequence of mining this trona, and that's due to the fact that when trona is mined, the trona ore seam actually releases methane, and that actually makes it fairly dangerous for the rest of the mining operations to continue. So when this company first began, they would flare the waste mine gas to dispose of it, which most underground mining companies do. And recently, they actually began capturing this waste mine gas, compressing it, dehydrating it, and then using it on these dryers to create the soda ash. The Department of Audit and the Department of Revenue actually found that by using and capturing this waste mine gas, the company was subject to severance tax, finding that the company was severing natural gas. the board agreed with the department, and this case is actually currently under appeal to the Wyoming courts. And the takeaway really from this case is this is the first time that waste mine gas has been subject to severance tax on a trona mine based on it being natural gas. And they claim that this is due to the change in use, which required a production process. And really, this is the first kind of example that we've seen the department really be fairly aggressive with the tax imposition statutes, and it remains to be seen whether this is going to be a continuing trend for the department.
Thanks, Casey. Now I want to briefly touch on another issue that is a fairly hot issue in the mineral production tax area. And looking at the results of our last poll, looks like a handful of you do work in the production tax area. This is definitely, mineral production tax appeals are really the majority of the work that we have done over time, although we do see more and more sales and use tax and traditional property tax matters. I wanted to touch briefly on an oil and gas issue that we've seen fairly recently. And as you can imagine, the valuation of natural gas for production tax purposes can be very complex. In fact, Wyoming's tax statutes provide about 6 different methods that the taxpayer and the Department of Revenue can use to value natural gas for tax purposes. One of those, and by far the most used method, is the netback method. In very simple terms, what the netback does is you go to the point of sale, you take the sales price, and then you deduct both processing and transportation costs that are required to get the gas to the point of sale. So you net back to the well by deducting processing and transportation. One of the big issues that's come up recently is, what does the statute mean when it says the deduction of transportation? And really, when it comes to transporting natural gas, typically what a pipeline will charge a natural gas producer is 2 different kinds of charges. The first is a commodity charge based on the amount of gas that's shipped. And the second is a demand charge, or a reservation fee, that the producer pays to the pipeline in order to reserve capacity on the line. And the question has been, is that second fee, that demand charge or reservation fee, part of the transportation charge that is deductible? State Board of Equalization back in 2017 said yes, based on a plain reading of the netback statute, the demand fee is deductible. Nevertheless, the Department of Revenue has continued to take the position that it is not entirely deductible. So that's an issue that continues to be litigated over what the netback statute means when it says transportation is deductible. And I guess the takeaway I would give on this one is, you know, the taxpayers in the state and the Department of Revenue and the board and even the courts are bound to follow Wyoming's tax statutes. It's the legislature and then the governor considering legislation that gets to decide how the tax system works, and in particular on mineral taxes, what kind of deductions you get in order to arrive at taxable value.
Then the last topic that I'm going to discuss with you here today is penalties for sales tax deficiency. And in this case, we have an oil and gas company who is appealing the department's decision to impose a penalty on them for underpaid sales tax. And pursuant to Wyoming statutes, the department is actually required to impose a penalty of 10% of a deficiency if the company is found to have negligently or intentionally disregarded the department's rules and regulations. And in this case, the board actually agreed with the department that negligence is found when an issue from a previous audit occurs again in this audit. So the oil and gas company in a 2012 audit had untaxed services that occurred at the well site during the production casing phase. And that was the same issue that had occurred in this current audit. So the takeaway really from this case is, if you're ever involved in an audit, definitely keep all of those records and really learn from that audit to make sure that you don't make the same mistake in the future that might result in an imposition of a penalty. And so now we'll do some questions.
I'm just going to take a quick look at the Q&A here. Looks like there were some questions that came up in earlier presentations. Let's see. Oh, thanks. Oh, looks like we've got one question in the chat. And the question is based on what Matt Michaeli and Bob Jensen said about the shortfall in state revenue. Are you seeing the Wyoming Department of Revenue increase audits or take more aggressive positions? That's an excellent question. And, you know, obviously we're not privy to some of the conversations that occur, you know, between the members of the Department of Revenue and sort of their decision-making process. I will say on one hand, I mean, I think I do believe the Department of Revenue is staffed with some really high quality individuals, very thoughtful group there at the Department of Revenue. And I think that they recognize the point that I made on my last slide, which is that if there are going to be substantial changes made to taxation in Wyoming at the state and local level, that needs to be done through the legislature as opposed to by the executive branch, the administrative wing of the Department of Revenue. So I would say on one hand, I think that the department definitely participates in that legislative process and recognizes that that's where those types of decisions should be made. But I would not be telling the full truth if I didn't mention that, you know, I do think that the departments of audit and revenue have always been aggressive in terms of trying to apply the statutes in a way that is legal, but also maximizes revenue. So it's not at all unusual to see fights at the audit level with the Department of Audit that may then lead to appeals to the State Board of Equalization on the mineral tax side. You know, at the county level, assessors are elected officials in the state of Wyoming. And so I think that that adds an element to the work they do. But again, just like the Department of Revenue, I do want to be very clear that in all of my work across the state, I have a very high regard for the professionalism and the approach that the assessors have taken, both at the county and state level. But excellent question, and we shall see as it moves forward. You know, Casey mentioned, excuse me, that we saw in that Trona case the imposition of tax on the waste mine gas. We do view that as a very aggressive move based on the imposition statute. I've got a quick question here, and this will probably end it for us. How often are appeals settled prior to going to the State Board of Equalization hearing? And that's a great question. And I will answer that by saying I would say about 50-50, which is maybe not the most helpful answer, but I would say on the mineral tax side, I have always noticed that the Wyoming Department of Revenue and its attorneys are very, very willing to discuss settlement. Only in the most extraordinary cases have they not been willing to sit down and talk. So I think I would say that the taxpayers engage in settlement discussions in the vast majority of cases, maybe 90%. Those obviously those discussions are not always successful, but you know they if the taxpayer is prepared to make their case to the department, there really is an opportunity to discuss. The same is true at the county level on property tax cases, and the same is true on sales and use tax cases with the department. Always a willingness to talk, I would say, not always successful in terms of resolving cases. That takes us to the bottom of the hour, 10:30, and so I believe we will hand it over to Sue and Bill.
Hi, everybody. Thanks for joining us. We really appreciate it. And this section will now transition. I always love to hear Walter and Casey talk about their practice area because they're on it and they know it very well, and it's very interesting stuff. So Sue and I do federal tax controversy and litigation, And we have a team of people that works with us. And as Sue mentioned, we represent clients nationally, but also here locally, and in state matters, federal matters, and sort of a wide variety of things. So unlike a lot of people who you have heard and will hear talk today, we don't necessarily have an expertise, a tax expertise in a particular area. We see all kinds of stuff. And so our world is an ever evolving constellation of issues and you know, just weird stuff to routine stuff that we help people resolve. But one of the things that we, you know, because we see all of these things, we're very used to, we're accustomed to adapting because we rarely do the same thing twice. And so the COVID situation, the pandemic, really changed our world. And so I'm going to talk a little bit about those kind of changes that we experienced, but then also transition to what we're expecting, because I think to the extent things changed as a result of COVID and the IRS organization essentially going from an in-office type organization, and you know, there are IRS agents worldwide, so going from in-office, going to places to work like all of us did before, to a complete shutdown of the organization in terms of their physical buildings. That was a huge change, but the change I think that's coming in the tax controversy space and tax litigation space, given what's going on in the Hill and with budget considerations, the conversation about Wyoming was very similar to the conversation that's happening at the national level. There's a big focus on the tax gap, which means there's going to be a significant increase in enforcement. And we'll talk a little bit about what's coming, because I think for those of you that are taxpayers, I think the comfort of not being audited or the comfort of taking aggressive positions and not being questioned may not be a comfort that exists anymore, and at least for the next 10 years or so. And for those of you that advise, I think the standards are going to be tightening up on advice, because there's going to be a lot more scrutiny coming in the coming years over what's being done now, and quite frankly, what has already been done in the last couple of years. It's just sitting there waiting to be looked at. But everything's delayed and backed up, and so it just now employees are starting to return to the office. And so what has that meant for us? Sue and I were in a very large, active controversy, an IRS appeals matter that was expected to go on for months. And the team was locked out of their building. So if they had hard copy files, they couldn't access them. And so the IRS team had to transition to all electronic. And, you know, it took a month or so, but then we transitioned into presentations. I know at one point I did a full day on video presentation, just like we would do in a conference room. And so there was adaptation. A lot of that stuff's going to stick because it saves a lot of money and not having to travel. And when we work on these large cases, there will be people flying in. There might be 20 people in the room, and everybody's flown in from someplace else. And so that's going to be a big push. Those travel costs and time incursions are going to cause a lot of virtual activity. But you know, a lot of people have asked about refunds because they've had 2019 returns that were filed in the fall of 20, and no refund yet, no hint of a refund. And according to the IRS, more than 1 million individual returns are yet to be processed, and these are paper returns, and large part of that, the backlog, was caused by just the fact that the initial reaction to COVID was to keep people out of offices and away from each other, so the return processing slowed to just a trickle. And then for entities, there's 1.5 million entity returns to be processed for 2019. So those are returns that people mailed in and still need to be processed. So the Taxpayer Advocate Service, which as Sue mentioned at the outset, I started my career as a government lawyer. You think I would be an insider, and you think I would know who to call. Well, I know lots of people in the government, and I call them, but there are problems that that cannot be solved by the traditional channels. And so the Taxpayer Advocate Service is a service that we use to help solve these sort of out-of-the-box problems for our clients. And not surprisingly, there was a dramatic increase during COVID. You know, people want to know where their refunds are and so on and so forth, but also, and very seriously, people in financial crisis and needing those refunds to pay rent or, you know, or just extreme to buy food. And that's the level of issues that the Taxpayer Advocate Service started facing. And there was more than a 40% increase in calls during COVID. And this number surprised me when I learned it a couple of weeks ago, that there's 1,600 employees in national and local offices in the Taxpayer Advocate Service. And so those of us that have to contact the Taxpayer Advocate Service, they have a centralized phone number now, and they're trying to centralize calls. So rather than call the local Wyoming person, the word from national office is the national leadership in the Taxpayer Advocate Service is, if you want to get in the queue to get something addressed, go through the centralized intake line, and then they're prioritizing the extreme hardship cases. Sue, let's go ahead and switch to the next slide. Thank you. So enforcement really slowed during COVID, and it's now ramping back up. So one area that was shut down but is now very active is the passport revocation or denial of renewal process. So there was in section 7345, it's been a few years now since this was passed, but a lot of people don't know about this, but if you have a passport and you have a large tax debt, the IRS can certify that debt to the Department of State, and they can revoke your passport or deny renewal of the passport. And so not surprisingly, the first handful of people that got passports revoked or denied, renewal was denied, there were court cases that came out of that, and the IRS has been winning those cases. And the program has been ramped up again. So it's something that I think that is a very real consideration for individuals if they travel internationally and have tax debts. It's something to be taken care of. So cryptocurrency, I know Wyoming has been a leader in crypto-friendly laws, and so there has been some activity, increasing activity. There was some pre-COVID activity, the Coinbase summons case, which was I viewed as a test case. I think everybody did, but whether or not John Doe summons could be issued to an exchange that handled cryptocurrency, and if so, was that enforceable? And new frontiers, old tools, new frontiers, and the courts have been allowing, and there have been two recent cases, the Kraken case and the other one, I believe, is Central. Those cases had government favorable rulings. One limited the scope of the summons, but the power is there. So what that means is, I think initially these exchanges had a lot of opacity to them, and so you couldn't, like, the government had no visibility to the transaction. So if people self-reported, fine, but if they didn't, then the government really didn't have a way to get information. And so these summonses is one way. But the other thing that's changed, which I think is very important, is the government's the IRS has wrapped its head around how crypto works. And they view it as personal property. So they view it just like something like a bank account or something like that. And they're starting to issue liens and levies with respect to cryptocurrency. And they also believe that they will be seizing accounts as well. So they're using the old tools, and they're treating a cryptocurrency just like a bank account. So I expect there's going to be significant uptick in the activity there, particularly given what's been going on with the crypto valuations, and the highs generate a lot of wealth for people if they cash it out. So I'll just skip to the high net worth individual audits. There's a big push now to increase audits for high net worth individuals. And so I think that's an area that's been trailing off over the last few years. And I think people who don't do what Sue and I do on a day-to-day basis, but have just a trickle of audits that they do for clients, it dried up over the last couple of years. There really wasn't that much activity. That's going to change. So Sue, let's go ahead and switch to the next. So we've got the polling question here. And this question I didn't know the answer to when Sue posed it to me. So approximately how many returns did the IRS audit in fiscal year 2019? So I'll let you go ahead and fill that in, and we'll just go ahead and go to the next slide, and we'll see the data get populated as we go forward. Okay, so what this slide shows is sort of the ebb and flow of audits, IRS audits. So this is corporate audits, and then it also shows certain Schedule C information for individuals. So that's individuals who have businesses. So this is all business oriented. And what we see is in the 2003, 4, 5 timeframe, we saw an uptick in audits. And then 2010 and 2011, we're starting reaching a peak, and then you see over the next decade, basically, a drop down of audits. And the most recent data we have is for 2019. So you can see that the audits have decreased. And so what happens when audits decrease is that the amount of tax that people owe, that's just based on income events. And there's a lot of information reporting. So the government can get a handle on just generally what they think taxpayers owe. But because we have a voluntary system, not everybody complies. It's about an 80% compliance rate. And so what happens is, and then of the people who do comply, what happens is not everybody reports everything that they owe. They might omit categories of income or overstate deductions or whatever. And so there ends up being a gap between what people pay and what the government is expected to get in revenues. In 2019, it was $600 billion. And so in a time like now, when the federal government is looking at ways to raise revenue because of COVID and other economic forces at play and budgetary forces, it's easy to say, let's narrow that tax gap. And that's exactly what is going on right now. It's being played out in Congress. The Commissioner of the Internal Revenue Service, Chuck Rettig, testified. And Chuck, by way of background, does what I do. He was a tax litigation and controversy person in California who I've known for many years. And so Chuck understands how enforcement works and the relationship. So it wasn't a surprise to me, his testimony on the Hill last week. But that's going to be a big focus. Let's go ahead and go to the next slide, Sue. Thank you. So the Biden administration has made a proposal called the American Families Plan. It was issued by Treasury just very recently this month. And this is a plan that's designed to give the IRS resources to close that gap. And so what does that mean? That means, and I should say that there appears to be bipartisan support for some form of this. So, I don't know how this proposal is going to play out in legislation, but there does seem to be general support so far for increasing enforcement. And so what does that mean? Well, there will be resources poured into increasing the scrutiny of what has been done to date. So like if resources were allocated to examining high net worth individuals tomorrow, what they would be looking at are the open years for those individuals. And so it would be going back to the behavior of 2018, 2019, when there was a different culture of compliance. And so the scrutiny always comes, and we know this from our world very well, the scrutiny that comes at the later time is not framed by what the culture was at the time that things were done. And so that always creates a disconnect, and people feel that there's unfairness to it, but the enforcement community just changes. The winds blow differently, and that the winds are going to blow differently. There's going to be a lot of scrutiny coming, and it's, you know, we're expecting it on corporations and individuals. That's easy to say, but we also expect it on partnerships. And for those of you that are you know, sort of involved with partnerships or following what's been happening from the IRS perspective, the IRS created a centralized partnership audit regime, which allows the IRS just at the high level to audit a partnership like a corporation. So it's one-stop shopping, and they don't have to go through the old system that required audits of all the partners and was very complex. So it's greatly simplified. And the thing is the IRS has lots of experience with entity audits. So it's much easier to transition a corporate audit expert into a partnership audit scenario. So I will go ahead and turn it over to Sue. And again, thank you.
Thank you, Bill. Going to our polling question, those of you that answered between 500,000 and 1 million got it correct. According to the 2019 IRS data book, it was approximately 770,000 audits of individuals and corporations and other entities. I will be supplementing what Bill just talked to you about in terms of what we saw happen during the pandemic and what we anticipate that means when we all, including the federal government, return to work. Starting with the first phase of the audit itself, the examination, obviously the examiners transitioned to remote audits, as Bill mentioned. By contrast, before COVID, typically, especially with large corporations, you would have the tax department and the federal agents working side by side, often in the same room, and often in a designated office space during examinations, which can last a fairly long period of time and last multiple cycles. So what was normally a more in-person discussion on how to run examinations for the taxpayer became remote overnight. So witness interviews that normally would be conducted in person and often with an attorney or other representative present were now being done by Zoom or WebEx or teleconference, which presented some logistical challenges, just like remote depositions do. Also, the IRS seeks information through what's called an information document request. And oftentimes the taxpayer and the government will sit down together before that request is finalized. So that discussion had to move to teleconferences. Also, taxpayers during a large examination often find it very helpful to have the IRS examiners, agents walk through, for example, the manufacturing plant that is subject to the audit, to show how the operations work, show the quality being generated at the manufacturing facility, and to discuss and answer questions in person. That obviously moved to remote. I have heard of taxpayers, doing virtual tours. So some logistical challenges. All in all, it seems that companies and individuals were able to navigate it successfully. The IRS added some flexibility in terms of how they accept and send out information. One example is the power of attorney form needed for an attorney or other representative to practice before the IRS on behalf of a client can now be submitted online. Moving to the second phase of the federal tax controversy process, and that is after the examination and the government issues what's called a revenue agent's report that states their proposed adjustment. If the taxpayer has a dispute with what the IRS proposes, we move into a pseudo mediation process with what's called the IRS Office of Independent Appeals. And they likewise moved from in-person conferences to virtual conferences, literally overnight. As Bill mentioned, in late December of 2019, we had been in a conference room in Indiana with approximately 20 people, if you count IRS appeals officers, the examination team, and the client team. And we presented for several days and negotiated in person. And for the same client on a different issue, in March, we had to move to, and in the summer of 2020, move and do the same type of thing, but this time virtually, using the same WebEx platform that we're using today. And so people had to adapt very quickly. Some of the downsides to doing it virtually is you miss that body language and nonverbal cues and sort of building a rapport with the IRS Office of Appeals, their team. On the flip side, some of the benefits that we found in terms of these online platform tools, for example, were the ability to concentrate the attendees' attention on a specific document or a specific demonstrative aid that we were using, which isn't possible in a typical conference room with IRS Office of Appeals. The other big change that actually would have likely come without COVID was the end of this pilot program by which when you go before the IRS Office of Independent Appeals, the examination team presents first, and the taxpayer gets to be in the room when they present. And then it's the taxpayer's turn to present their position. Well, historically, the exam team would leave the room, and the taxpayer would present just to the appeals team, the neutral team that they're negotiating a settlement with. And the pilot program allowed the examination team to be in the room during the taxpayer's presentation. And I personally found it to lead to a more adversarial setting, perhaps less productive and a bit more disruptive. And it seems like that seemed to be the consensus of taxpayers that provided comments on it. The last stage that we'll talk about today is, oh, go ahead, Bill.
Oh, I was just going to jump in because I know we've gotten a couple of questions. One is,
okay, great.
On the high net worth individual, what's the dollar amount? And you know, there's no set amount yet that's been identified, and they may not identify publicly what the amount is. But I've heard, you know, individual income. So on a 1040, it'd be 500K. I've heard $1 million, and I think somebody floated 400K somewhere, and it was criticized very heavily because that's starting to dip into the working family, two-income families in urban areas, expensive urban areas, and so it's gonna be. They're clearly going after people, so it's not necessarily a net worth issue. It's more of an income issue. So, and the other question that we have is what are the issues that are going to court? And I know, Sue, you're going to jump into the court stuff, but as it just continues to tend to be like we're litigating transfer pricing cases. There's a lot of conservation easement cases, a huge volume of conservation easement cases, and then there's just always issues. The IRS identifies campaigns on their website with respect to large corporate taxpayers, and then also other areas of emphasis. And if you haven't gone on the website and you know in your sort of touch this space, it's a robust source of information. It used to not be that way, but it's gotten that way. But we do a lot of transfer pricing and international tax issues.
That's right. And to be sure we have enough time, I'll move on to our last polling question. What percentage of cases filed in the U.S. tax court settle before going to trial? And this is a fill in the blank. Okay. While we're waiting for the results of that poll, I will add that There are no, in the U.S. tax court, there are no in-person trials at the moment. At some point there will be. The tax court adapted by making exhibit deadlines and pretrial deadlines go earlier. We're expecting those to remain. They changed the third-party subpoena process to go virtual. They rolled out a new electronic access system called Dawson, which allows petitioners to file their petitions electronically. And they've opened up the court proceedings on YouTube. If you go to the tax court website and you want to watch a specific docketed item for trial or hearing, once it's opened up, the tax court opens it. And so we are at the end of our presentation. We can show the polling results, please. Great. Well, the answer, for those of you wondering, is 85%, a high percentage. Closing remarks, where do we think things will end up post-pandemic? The IRS might go back to fully in person and abandon these remote auditing procedures, but more likely than not, they'll stick with some of these procedures. And with the new administration's renewed focus on enforcement, we should expect an uptick in federal tax audits and tax litigation. So with that, we're going to move into a break. And we ask that we will be starting promptly at 11:05. So thank you so much for participating.
Rebecca, can you speak so we can just do a quick sound check?
Sure. Can you hear me?
Yeah, you sound great. Thank you.
Okay, great. Yeah, I'm on my phone for audio.
Yeah, you're all set.
Thanks.
Okay, welcome back, everybody. We're almost right at 11:05, so I'll do a quick introduction of our final two presentations today. Rebecca Shore will be speaking first. She is a partner in our Denver office. Rebecca advises clients, fiduciaries, and families relating to the transfer and management of wealth. She frequently advises professional and family trustees and Wyoming trust companies regarding fiduciary duties and trust administration. Rebecca also represents clients, including in Wyoming, probate and trust litigation. After that, we'll have our final speakers, Bob Keating and Diana Myers. Bob advises clients and acts as a consulting or testifying expert on matters of business organization, federal tax, and professional responsibility. Bob is an attorney in our Denver office. Diana Myers is an attorney in our Jackson, Wyoming office. She represents and advises clients with respect to federal tax controversy and private client matters. Diana brings experience from her previous law firm of Baker McKenzie and time with Northern Trust covering tax reform litigation for the company and high net worth clients. So with that, I turn it over to Rebecca. And again, thank you everybody for joining us today.
Hello, everyone. Thank you for attending this morning, and thank you for hanging in there for the full length of the presentations. It is a pleasure to speak with you all. So I'm going to be talking just a little bit about Wyoming unregulated private family trust companies. Throughout the presentation, I might use the term PTC, and that's just short for not having to say so many words every time I mention it. Several of these topics could be the subject of entire presentations, and so I'm going to try to give a nice overview in the next 25 minutes, but just realize that a lot of these topics are complicated and could be talked about for a full presentation in and of themselves. So let's start with what is a PTC? What are we talking about here? So looking at the spectrum of the types of trustees that act for trusts, private trust company falls somewhere in the middle. So oftentimes families appoint family members as individual trustees of their trust. That's probably the most common trustee that you see. Another choice would be a professional individual. So maybe an attorney or an accountant or some other trusted advisor might act as trustee of a trust. Then there's the option of a private trust company, which is something that's specifically allowed in Wyoming and some other states, a handful of other states as well. So within the category of private trust company, there's a couple of different iterations. There's a chartered trust company, private trust company, that is regulated by the Wyoming Division of Banking. This presentation today is focused on an unregulated private family trust company, which is not regulated by the Wyoming Division of Banking. And there's several features, and I won't go through all of them, but there are several features that the PTC has to have to qualify to be unregulated. For example, that PTC can only act as trustee for a single family. And under the Wyoming statutes, a single family is essentially you take a designated relative and you can go 10 degrees of lineal kinship and 9 degrees of collateral kinship. And it includes spouses and key employees and a few others. But generally speaking, the concept is that it only acts as fiduciary for one single family. In Wyoming, for an unregulated PTC, there is no capital requirement, and it's an entity created by the family, usually an LLC or a corporation. So on the spectrum, from there, you go to a public trust company, which is a company that holds itself out to the public and acts as trustee for many trusts and is obviously regulated. And then at the end of the spectrum, you have a bank with a trust department, which people are pretty familiar with. And then you've got the entire suite of bank services that go along when you're using a bank. And so what are the benefits of a PTC? Why use one? Why are they so popular? These are the major benefits of a PTC. First of all, it allows for centralized management for the family. So very similar to a family office. It provides one place where the family can have an entity that administers all of the family trusts. Along the same lines, it provides an option for trustee succession. Oftentimes, family members struggle to determine who's going to act as successor trustee, who should I appoint, And this just provides an answer for the family. So it allows for easy trustee succession. It also allows for, it's a vehicle for family governance. So you can have members of the older generation acting within the PTC, and as members of the younger generations, grow older, they can also have roles in the PTC and learn from the older generation. And so instead of just handing a trust off to a younger family member and saying, okay, you're the individual trustee of this trust now, good luck figuring out how to administer the trust, this provides a nice way to have that institutional knowledge and pass it down throughout the family. The next pretty significant benefit is liability protection. So when a family appoints an individual as trustee, that trustee is subject to potential breach of fiduciary duty claims where they could have personal liability and have to return funds to the trust based on the outcome of the lawsuit. When you have a PTC acting, the entity itself is actually the trustee, not the individual. And so the individual holds a role within that PTC, and we'll talk about the structure here in a few minutes, but that person is just acting within the entity. There's a fairly significant debate, and there is certainly an argument that when an individual is acting within the PTC itself, within the entity, that they are subject to the business judgment rule, to that standard, as opposed to the higher fiduciary standard. And so their role on the board of directors or as a manager or as a committee member, their decisions are subject to the business judgment rule and not subject to a fiduciary standard. However, the overall decisions of the entity as trustee would obviously be subject to that fiduciary standard. And that is one of the topics that could be the subject of an entire other presentation, but that is definitely a benefit of a PTC. So the last benefit, I think it's no secret to anyone who's on the call today that Wyoming is a very popular trust situs. And so we're going to talk a little bit more about that, and that leads me to my first polling question. So Wyoming law allows for which of the following? So everyone answer and see what they think about Wyoming's trust laws. And while you all are answering that, I'm going to move to the next slide and start talking about the benefits of Wyoming situs. So obviously, the first big benefit is that Wyoming does not have state income tax. So if the trust has the right tax characteristics, for example, if it's a non-grantor trust and it pays its own income tax, then Wyoming is a very attractive place for it to be, depending on a variety of circumstances of which my colleagues in the tax group can analyze and determine whether or not it is beneficial and how beneficial. But it is certainly a benefit to have situs in Wyoming. And a private trust company can give a family the anchor that they need to have Wyoming situs. They can have a manager up in Wyoming, and then they can have family members from all over the country act on committees for that PTC, act on a board of directors, or be a manager in that PTC. And I know there are several companies in Wyoming that will act as part of a client's private trust company to provide that specific anchor to Wyoming for income tax purposes and other purposes, as we'll go through here. So Wyoming also allows for specialized trusts that aren't available in other states. They are in a handful of states, but Wyoming is one of a handful of states, for instance, that allows domestic asset protection trusts. Domestic asset protection trusts require a qualified Wyoming trustee, and a PTC is a Wyoming qualified trustee. And Wyoming also allows for wing trusts, which are Wyoming incomplete gift non-grantor trusts, and those trusts also require a Wyoming qualified trustee, and the PTC could act as trustee of those types of trusts. And we'll talk a little bit more about those trusts here in a bit. So before I move to the next bullet, looking at the polling results, it looks like the answer was fairly obvious to the vast majority of you, which is that Wyoming allows all of the above. And that is one of the reasons why Wyoming is such a popular trust situs. It has fantastic trust law. And first, it actually has trust law, which not all states have good, robust trust law. So it allows for a ton of flexibility in the administration of trust. It allows for decanting, directed trust arrangements. It allows for blind trusts, and it allows obviously for private trust companies. And so privacy is a big reason why people like Wyoming for trust. And the blind trust that I just mentioned, for example, a settler can create a trust in Wyoming and really restrict the information that the beneficiaries receive, and some settlers find that very attractive. And that's something that is somewhat unique to Wyoming. In addition, Wyoming has great LLC law as far as privacy goes. And if you have to file a court action involving a trust in Wyoming, Wyoming has a statute so that when that petition is filed with the court, it is access is automatically limited to that petition, so you don't have to file some other motion to seal or motion to limit access that you might in another state. And so that, I filed quite a bit in court, and that is just a really, really great benefit of Wyoming. Which leads to the final bullet. The governor has ordered the creation of a chancery court in Wyoming, which will hear certain business disputes and also disputes under the Wyoming Uniform Trust Code. The judges are supposed to have specialized expertise in those areas, and it's supposed to allow for expedited handling of those matters. And I think that will be a huge benefit in Wyoming also if a proceeding needs to be filed under the Uniform Trust Code. So let's talk for a bit about what this PTC looks like. The slide that's up right now shows you a very basic common structure, and these can be customized depending on the family and the family's goals. But this is a very common structure, and one of the ways that the PTC is often owned is by a family trust. In particular, in this diagram, the PTC is owned by what's called a special purpose trust. So Wyoming allows for a purpose trust, which is a trust that exists for a purpose as opposed for just the benefit of the beneficiaries. And that purpose can be to own a PTC. And so it provides a nice anchor there at the top that is perpetual, because one of the other alternatives is to have the family members own the PTC directly. And then you run into the problem that when a family member dies, what is the succession of the membership interest of that family member? How are you going to handle that transition to the next generation? And how does that play into the members' powers in the PTC? And it just eliminates that complication because the special purpose trust is there and just owns it in perpetuity. It also is really beneficial if you have a family member who wants a divorce from the PTC or from the family, or maybe just doesn't want to use the PTC for their family trust and wants out. And so the special purpose trust eliminates having to get that person out of a holding company or out of a direct ownership of the PTC. And so the special purpose trust can be a really great tool to own the PTC. Below that, we've got this very typical structure. This is obviously the structure with an LLC because it has managers. And what it does is it divides out the basic aspects of a trusteeship into committees. And so the PTC can certainly have more committees, but this very basic structure is based on an IRS notice. It's IRS Notice 2008-63, and this notice addresses the structure of a PTC when the PTC is acting as trustee of your typical dynasty trust. So a trust that's created for estate and gift tax benefits, this is the structure that you typically see. Your investment committee is in charge of investments for the trust and is much more flexible from a tax perspective. It's not as tax sensitive. There are some small things that are tax sensitive, but it's much more liberal as to who can be on the investment committee and how it can involve family members. The discretionary distribution committee takes your most tax sensitive issues and consolidates them in one committee. And those issues are things like distributions to beneficiaries, the power to decant, the power to modify the trust, the power to exercise discretion to allocate between income and principal. All of those powers that might cause estate tax inclusion if the trustee has them and the trustee is interested. So if the trustee is also a beneficiary or is a donor to the trust, et cetera, those are consolidated in your discretionary distribution committee. And in the basic structure, a lot of times families will just appoint independent people to be on the discretionary distribution committee, and that will just work across the board because those people are not family members and they don't need to worry about estate tax inclusion. The amendment committee, which is hanging out over there on the end, is really just there in case something needs to be changed with the discretionary distribution committee. So the amendment committee acts, usually independent folks, and it acts to revise the operating agreement if that will change the composition or anything about the discretionary distribution committee. So it's really there just for protection from a tax perspective. And as I said before, there can be additional committees, oftentimes there is, or the remainder of the trust administration and the kind of day-to-day running of the company can be vested in the managers. And the managers can also obviously hire folks to do those jobs, can appoint, an administrative manager, financial manager. If it's a corporation, you may have a president. All of that can be sort of in your governance here at the top. So now that we've looked at that structure that is created for when we've got this sort of tax-sensitive situation for estate tax inclusion, it's pretty simple if you've got independent people on that discretionary distribution committee, but oftentimes family members want to act on that committee, and it becomes a little more complicated from a tax perspective, and that's where you really need, we'll talk about in a bit, the expertise you need to manage these things, but that is where you need to decide you need to look at what the trust says, and you need to decide what kind of flexibility you need in the operating agreement to allow them to act and for them to know when they need to recuse themselves or not participate in certain decisions. The other piece that I want to talk about is making sure that the PTC has flexibility to act as trustee of other types of trusts. For example, the family may want to appoint the PTC as trustee of a revocable trust. Maybe the family wants to pool investments, or they just want the PTC to act as their their trustee of their revocable trust. Well, a revocable trust is basically a nothing for tax purposes, so there's no reason to have tax-sensitive committees acting if the PTC is acting as trustee of a revocable trust. So inside of the operating agreement, you want to have some flexibility to really understand what the family wants and who they want to act in that scenario. And it doesn't have to be the same for every trust. That can be built into the operating agreement, or you can even have an intake form where you sort of assign these roles depending on the trust when the PTC is appointed as trustee. So along similar lines, also with a domestic asset protection trust and with a wing, like I said before, you need a Wyoming qualified trustee, but the tax characteristics of these two trusts are very different than a trust that is created to avoid or to hold a completed gift or to avoid estate tax inclusion. So just as an example, looking at the wing at the bottom there, that trust is used solely for income tax benefit, well, for asset protection and for income tax benefit. And I saw in an operating agreement for a PTC, there was some language that said that nobody can take any actions if that action would deem a gift to be incomplete. And I thought to myself, well, if this PTC were acting as a qualified trustee of a wing, you wouldn't want that language, right? That because it, by its very nature, it is an incomplete gift trust. And so understanding the nature of the trust and the tax characteristics of the trust and making sure that the PTC operating agreement jives with that, and that your client's goals are being met, and you don't have things in that operating agreement that are unduly restrictive depending on the trust. Another piece to think about with the administration of a PTC is, again, to have even more flexibility and structure. So Wyoming has, and a lot of states do, but Wyoming has directed trustee statute and the ability for a delegated trustee arrangement. So first, a directed trustee arrangement is an arrangement where in the trust document itself, the different roles of within the trusteeship can be separated. So for example, you might have a trust advisor in the trust that's going to handle investments. You might have a trust protector in the trust that's going to handle distributions. And so those roles can be separated out within the trust. And then it's great under the Wyoming statutes, those people, there's no cross liability between those people. And so once those roles are separated out, they act sort of on their own, and the other piece is not responsible for monitoring the conduct of, the trust protector is not responsible to monitor the conduct of the trust advisor, for example. So using a PTC, you might have in a trust document, the family might say, okay, well, we want this certain individual to handle investments. So within the directed trustee arrangement, we're going to appoint this person as a trust advisor. They're going to handle investments. And now your PTC is just appointed to handle the remaining trustee functions. Make sure that that operating agreement and the ongoing operation of the PTC, you know, that you can have that arrangement and it's not confusing, right? Because you also have an investment committee in your PTC. So you might want to have a direction in the operating agreement that says if the PTC is acting as a directed trustee, in this particular circumstance, it might say decisions will be made by the distribution committee, because here the PTC would have that role of making distributions. Similarly, but slightly different, is a delegated trustee arrangement. So with a delegated trustee arrangement, you've got a single trustee. So in this example here, you've got an individual who is acting as trustee, and that individual has the ability to delegate any powers of the trustee to an agent. And so if you've got an individual acting, that individual could say, my family's got a PTC and I want to handle this aspect of the trust, but I want to delegate the remaining aspects to the PTC. And the biggest difference between this arrangement and a directed trustee arrangement is that with a delegated trustee arrangement, that individual trustee does have a bit of a duty to monitor what's going on if the trustee has delegated that. But the PTC can be used to take on any of those roles, and I've even seen it take on roles where it's just doing the administrative back office, if you will, role of a trustee. So in other words, the family member wants to use the PTC to do accountings, to keep the books, to do some of the functions that an individual trustee isn't really going to want to do. And so there's a lot of flexibility there, but just need to make sure that the PTC, that the people in the PTC, the operating agreement, and everybody working in the PTC understands how to handle those engagements and is not confused and does not have to use all of those committees if all of those committees are not necessary. So this leads me to my second polling question, which I want to discuss in just the last few minutes that I have. And it asks what areas of expertise are helpful for the implementation. And it's not just the implementation, it's also the operation of the PTC going forward that these things can be helpful for. So please answer that. And while you answer that, I'm just going to talk for a moment about thinking about whether a PTC is a good idea to begin with. And so before you even get to this stage, one thing I've seen happen with PTCs is they are so incredibly popular right now that it's sort of, people tend to jump to the conclusion that they are the correct answer for the family without really doing the analysis of whether it fits for a certain family. And so some of the things to consider when you're thinking about if you're helping a client with whether or not they actually want to move forward and do a PTC is consider the wealth of that family, because the implementation and ongoing operation of a PTC are expensive. It's expensive, and it's involved. You know, it's sort of it's akin to a family office, but it's another structure. And so if the family is large enough and uses a family office, then certainly a PTC may make sense. But there's certain clients where it's sort of a hard decision. And one of those things that can make it a hard decision is, does this family really need a PTC, a trustee for several generations? Is the family large enough? Is this something they really want as part of their family governance for the long term? And so thinking about some of those things before you even move forward is really important. So looking at the results of the poll, again, I think my questions are too easy because the vast majority of you got this correct, and it's all of these pieces. And so trust and estate law is key, because you need to understand, you need to have somebody who understands the tax characteristics of the trust, the terms of the trust, and how the PTC has been appointed and what roles the PTC is going to take on. And then within the PTC, who can act? What about the tax-sensitive powers? Are you making sure at meetings of the PTC that people are not participating that shouldn't be participating from a gift and estate tax perspective? Things like that. Secondly, income tax, also very important, not only in the implementation of forming a PTC, understanding tax characteristics of the trust, but also in the structure of the overall family has. Things like maximizing deductions, making sure that the structures make sense, all of that is in the income tax realm. Then state law requirements, understanding Wyoming law. What does it require to set up a PTC, an unregulated PTC, if that's what your clients are looking for? Securities law. an unregulated PTC typically falls under the family office exemption for SEC purposes. So understanding that exemption and making sure the PTC qualifies at inception and on an ongoing basis. Accounting. Obviously, accounting is helpful for the administration of the trust, for setting up the PTC and maintaining its tax returns and everything else. And so I am at 11:30. This is my last slide. I really appreciate everybody coming, and hopefully you all learned something about Wyoming private trust companies. Thank you, everyone.
Bob, you might be on mute.
The joy of Zoom conferences. I'm Bob Keating, and I have Diane Myers with me, and we're going to be talking about what appears to be going on in federal tax legislation. I can tell you that everything we're going to tell you is highly speculative, and that there are some trends here that I think are worthwhile. But I think that what we're really hoping to do is to kind of give you a feeling of what you should be looking at as federal tax legislation develops over the next 4 to 6 months. And start with a very simple polling question. Since January 1st, have you spent more than 2 hours trying to follow the federal income tax proposals? That's a yes or no question that's over in your polling area. As you know, there have been a number of tax legislative changes tucked into all the coronavirus kinds of protective changes, and they extend over all of the last year and into the beginning of this year. Most of these changes had to do with affording some tax relief with regard to some of the rules that have been around for a while, and some of the TCJA rules that were there, but have principally been dealing with matters other than tax. In those bills have been a couple of tax points, and we'll touch on that as we go along. But essentially, with the beginning of 2021 and the beginning of the new administration, there are two principal tax plans that have been released, and a terrific number of other tax bills that have been introduced. The first is the American Jobs, the tax portion of which is called the Made in America Tax Plan. What that's essentially going to do once it's fleshed out is it's going to be dealing with the infrastructure developments, and it's heavily related to corporate taxation and international taxation. And that's half of the tax program that the Biden administration has come up with. The second half is the American Family Plan, and that is more focused on individual tax matters, estate and trust. And as Bill indicated a little earlier, it also includes a proposal for a significant contribution to IRS funding and IRS resources going forward. We won't be talking about that because I think Bill did a good job of sort of summarizing what's going on. In the meantime, there have been several other bills that have been introduced, and some of these have provisions that aren't within the Biden proposals. Some cover the same ground as the Biden proposals. I've listed two of them on this slide, and I know Diane is going to mention a couple of them when she gets to the wealth transfer tax kinds of provisions. So if I can't tell you what's going to happen, can I tell you when it's going to happen? And I'll draw on my friend Tom Rutledge's great title. A person who tells you when tax legislation will be passed will lie to you about other things as well. And I think that we have seen suggestions coming out of Congress and from annotators to the effect that the tax legislation needs to be completed by the 4th of July. The tax legislation will be completed by the August recess. Early recommendations said that the tax legislation could not be completed until October because the fiscal year 2021 revenue reconciliation process had been availed of to adopt one of the earlier bills that's already been passed. But in fact, that's not the case. The parliamentarian of the Senate has ruled that the reconciliation bill that was passed earlier can be amended, presumably as many times as the Senate cares to do that. And there is now some talk that there will be an amended reconciliation with respect to some of the tax legislation that's currently pending. The reason we care about the reconciliation is that certain things can be passed with a simple majority. And we have right now an even split within the Senate with the vice president casting the deciding vote, which would mean that a 50-50 split on one of the Biden tax proposals could be adopted if it could be made part of a reconciliation bill. Otherwise, they'll need to get 60 votes in order to avoid a filibuster. So I think that what that means is that there are probably a couple of tax bills that we can look forward to seeing, and those could be broken up in a number of ways. One is it could be broken up into the infrastructure and the family plan bill. What I'm hearing, and I'm seeing the same things most of you are seeing, is that it's more apt to be divided into some of the infrastructure about which there may be agreement, which may actually pass without needing to go into reconciliation, and other provisions that'll be part of the reconciliation. The most important thing, I think, for people who really want to understand what's going on is the first item on this slide. And I would strongly suggest that you hang on to this website site for the Green Book, because Green Book is going to be where many of the things that we're not going to be able to answer today will at least be fleshed out. Now, that doesn't mean that that's what will actually be adopted, but as you'll see in just a second, there are a bunch of questions that we're going to be trying to work through as we look at the more specific legislative language that does not yet exist for either of these two tax plans. When you're looking at them, a couple of things that I think you want to look at. A lot of this is going to have to do with the bill that was passed in 2017, the Tax Cuts and Jobs Act. Many of the changes are looking to reverse decisions or modify decisions that were made in that. There are a lot of provisions, and we're not going to talk about the non-tax provisions of these plans, but a lot of them are talking about social and environmental programs, and I think you're going to see a fair amount of that. Interesting to me is that some of the proposals are going to call upon an increased use of, I assume, appraisers to determine fair market value as opposed to adjusted basis and taxable income. And they all many of these things are looking at balancing taxation of services as opposed to taxation of capital, and sort of, again, putting a little more emphasis on services up to a certain amount. The questions that I think you should be asking yourself as you look at these proposals is, there will be proposals talking about a taxation, but sometimes they'll talk about gain, sometimes they'll talk about income. The Green Book will tell us whether we're talking about adjusted gross income, taxable income, the amount of capital gain, or something else, such as the amount of gain on a like-kind exchange. How much is when are these taxes going to kick in? As Bill mentioned, there's been discussion in a lot of the proposals that the taxes are going to hit people above $400,000. The current speculation that I'm seeing, and I'm not seeing it cited to anything, is that it may be in the neighborhood of $452,000 for single filers and $509,000 for joint filers. And of course, as has already been pointed out, that comes down to a lower rate than $250,000 or $400,000 for a married couple if you count the two spouses separately. And then there are some taxes that are going to be imposed on income over $1 million or gain over $1 million, and these are some of the high income matters. And one of the points that you need to look at with respect to each of these when you're applying these thresholds is that, you're looking at a corporate tax and a state tax, and then they talk about individual joint returns and households in some of the proposals. With that, I will turn it over to Diana.
Thanks, Bob. We can advance to our next polling question, which deals with the topic of international tax. And so I will give you all a moment to answer that if you kindly would. And now that we have you primed for international tax topics, we will turn back to the domestic agenda, where we'll talk a little bit about the transfer tax proposals that are happening at the federal level. The transfer tax proposals are coming from 3 different areas. First, we have President Biden's American Families Plan, which is a 20-page white paper with, as Bob said, no supporting legislative text. We also have the STEP Act, which has been introduced in the Senate, and also the For the 99.5% Act, which also has been introduced in the Senate. So we'll start with the American Families Plan. The only transfer tax proposal in the American Families Plan is that the step up in basis at death that we enjoy on our assets will be eliminated. I would love to give you a numerical example of what that might look like, but the reality is that this white paper simply does not contain enough detail. However, if we want detail on what elimination of a step up in basis for assets at death might look like, look no further than the STEP Act, which stands for Sensible Taxation and Equity Promotion Act of 2021. It was introduced by Senator Van Hollen of Maryland in the Senate just this past March. And what this act says is that transfers by gift during life or at death are subject to immediate gain recognition for federal income tax purposes. In other words, if you make a transfer of assets with some built-in gain in them during life or at death, it will be as though you had sold those assets. Lest you think that you could avoid this by transfer and trust, of course, that's not the case. The STEP Act does contain special rules depending on whether you are transferring to a grantor trust or to a non-grantor trust. Now, I should mention there are exceptions in the STEP Act. So there is an exception from the gain recognition if you transfer to a U.S. citizen or U.S. resident spouse. There is an exception if you make a transfer to charity. And there also is an exception for the first $1 million of gain. So those ameliorate, to some extent, what could really be a significant liquidity problem when we start getting into deemed gain in the tax code. On the topic of liquidity problem, the statute does say, or the draft legislation says, that you can elect installment treatment over the course of 10 years if you, of course, are willing to pay the federal government interest on the amount of tax that you defer. Perhaps the most notable thing about the STEP Act and the planning pointer for this year is that the STEP Act, as currently drafted, is retroactive to January 1st of this year. So what does that mean? Well, when a client calls you and says, okay, what should I be doing from a wealth transfer perspective right now? The high-level answer is, look, right now we enjoy, by historical standards, very high exclusion amounts for the federal estate and gift tax. And so if you, client, are thinking about some wealth transfer planning, now could be a pretty opportune time to make some transfers. That said, if the STEP Act were to become law in its current form, be aware that a lifetime transfer that you make this year could be subject to this deemed gain recognition. So that is the asterisk for planning this year. Could be a really nasty surprise for a lot of clients. We will turn now to the final piece of legislation which has been introduced. It is the For the 99.5% Act. Senator Bernie Sanders introduced this legislation in the Senate also this past March. And if you've been hearing a lot about really dramatic changes to the federal transfer tax regime, this would be the source of that buzz. So to give you a sense for the tenor of the conversation, if you read President Sanders' release about the summary of the draft legislation, it does include a list of what he considers America's wealthiest families taken from Forbes data, and will show you exactly how much more each family will pay in federal transfer tax under the bill. So I commend that to you in case you might like to see how much more federal transfer tax your client might pay under this proposed legislation. This For the 99.5% Act does a couple of different things. First, it lowers the estate and gift tax exclusion, the estate tax exclusion down to $3.5 million. And it lowers the federal gift tax exclusion down to $1 million. The federal transfer tax rate goes from 40% to 65%. The minimum term for a GRAT is 10 years, which eliminates the use of rolling grats for all intents and purposes. The draft legislation also sets a minimum for the remainder interest in a GRAT. And that minimum number is the greater of two things, either $500,000 or 25% of the assets that are transferred to the GRAT. So as you can see, it's a pretty sizable remainder interest, pretty big change there. The draft legislation sets a minimum term of a maximum term of 50 years on any trust to which GSTT exemption has been allocated. So regardless of your state's rule against perpetuities. This draft legislation says maximum term of 50 years. And it also says that for lifetime transfers to trust, the annual gift tax exclusion is capped at $30,000 per person, regardless of how many recipients or donees are in the picture. So it essentially limits your use of the annual gift tax exclusion in order to make gifts and trust. The question for all of this draft legislation is, okay, so, to Bob's point, is this stuff going to become law? And I think it's helpful to think back to 2017, when in June of 2017, there were tax reform proposals floating in the ether, and we all sort of thought, this is talk as usual. September of 2017, both houses of Congress started to get some traction and look really hard at tax reform, and we thought, okay, maybe we should read an article here or there, see what's actually going on. And then December 22nd, 2017, the president had signed something into law, and we were all, if not caught off guard, at least had wondered how we had gotten from 0 to 60 so quickly. So to Bob's point, the timeline on this is anyone's guess. With that, Bob, I'll turn it back to you.
Thanks, Diana. I remember December of 2017 having made the statement, which I've regretted ever since, that it's only 3 weeks until Christmas. There is no way they can get all of these things put together in time to have it effective on January 1st, 2018. So at this point, I think everybody should expect that there will be something down the line, no matter what people say about the impossibility of getting it done. And I think that it will be interesting to follow. I'm going to just touch real quickly on some fairly specific things. First of all, there's in the infrastructure plan, there's a recommendation for a 28% corporate tax. You'll see quotes all the way through here, and these are quotes from the most current government statements that are out there, which are these short descriptions. Joe Manchin has indicated that he'd rather see 25%, and they'll need his vote in order to get something passed. And that comment may make a difference in this. Part of the corporate rate issue is tied to a bunch of international things which are described in the infrastructure plan, and we'll see how those all play out to some extent at a meeting of the OECD taking place in July, when there'll be discussions about possible minimum taxes in other countries. Domestically, there's a talk about a 15% corporate minimum tax. In the TCJA, the corporate minimum tax was permanently eliminated. Most of the individual taxes were merely put into effect until 2026. So this would be adding something that had been permanently repealed. You'll see some things drafted for fossil fuels, transferring from fossil fuels to renewables. Much of the infrastructure plan talks about that. Bill's already told you about the ramping up of enforcement. Now we're shifting over to individuals. They're talking about restoring the top level for individual tax at 39.6%. And it will be interesting to see where exactly they they draw that line, but that's one of the things that they're talking about here. They are also talking about eliminating capital gains for households making over $1 million, which would take the capital gains from 20% to 39.6%, if that happens. Carried interests are one of the provisions that were put in as an individual temporary provision in the TCJA. They're now talking about not only making what's called 1062 permanent, but also possibly adopting something that may not merely require holding for 3 years, but say that the interest will always give rise to ordinary income, even if with the income being passed through would be capital gains to the partnership. So it'll essentially it'll be the 1061 provisions on steroids. They're looking at requiring the recognition of gain on like-kind exchange if there's gains over $500,000. That's one of those things where that will require a valuation on like-kind exchanges, among other things. The 461L is a provision in the TCJA, which would expire. They're now talking about making it permanent for those making over $1 million. And again, we'll have to see what that looks like. And an item that's particularly of interest to me, dealing with unincorporated and pass-through entities, is that they are looking at filling in a gap in the Medicare self-employment and NII tax so that everyone will pay either employment tax, NII tax, or self-employment tax on all of the income. This is because of a peculiar way in which the initial provision was written. I commend the report down there at the bottom that explains this issue. However, one of the many things that had been talked about that did not make it into any of the proposals is the idea of imposing what's called the OASDI tax, the portion of FUTA that goes to essentially to Social Security for people with income over $400,000. That's not in the provision, the provisions that are outlined. But as I mentioned earlier, some things aren't in this, but you may find them in it later. Some things that are in it may fall out later. And that's going to really start over the next few days when the Green Book comes out. Thank you again. I appreciate your taking the time to hear us. Now I think you're muted.
You got me, Bob. Thank you. That concludes our presentations for the first annual virtual Wyoming Tax Conference. Delighted to speak with you all. Thank you so much for joining us. This last slide provides a reminder on your CLE and CPE credits. So thank you again for spending time with us this morning, and we hope that you all enjoy the rest of your day. Thank you so much.